The trust of the innocent is the liar's most useful tool. Hello everyone. Today we are going to take a deep dive into the fraud and its essentials under free consent in contract law. Fraud in contract law is intentional deception that misleads another party into unfair conduct. It includes false statements, concealments, and deceptive acts that induces consent. While silence is not actually fraud in this case. Fraud makes a contract voidable, allowing remedies like recession and damages, and may lead to criminal liability. Understanding fraud helps to prevent fairness and prevent dishonest practices in business and law. Now let's analyze this in legal terms.
False statement is the goal of fraud. If one party knowingly makes a false representation intending the other party to rely on it, this constitutes a fraud. False statement must be knowingly fraud. The person making it must be aware of its falsity. Intent to deceive. The purpose of this must have the intention to deceive another party. Start.
I hope this property has approval.
Yes, ma'am, everything is fine.
But I don't think so this property has any approval. I think you scanned it.
I never said this had any approval. I just said it was fine.
Hence, half-truth is misleading. However, mere silence is not considered fraud. If the seller knows about a defect but decides to stay silent, it's generally not fraud unless specific exceptions apply. Exceptions: duty to speak when a contract requires full disclosure. For example, a seller must disclose hidden defects in a real estate. Silence equals speech. If one party creates a false impression and does not correct it, for example, selling a car as brand new when it has been repainted. Change of circumstances. If a previously true statement later becomes false, there is a duty to disclose it. Half-truths. When a statement is partially true but misleading. For example, saying a phone is almost new without disclosing that its battery is replaced.
Active concealment is a fraud when one party deliberately hides a material fact to deceive the other party. For example, a vendor sells a house with severe plumbing issues and covers them up. In the case laws, we have Schneider versus King, in which a seller concealed the defects in a ship by keeping it afloat during the inspection. To hide that the ship was unseeable. Legal standpoint is that if a concealment is intentional or influences the other party's decision, then it is a fraud. Another type of fraud is making promises without intending to fulfill it. If a party makes a promise knowing they will never fulfill it, it is fraudulent. For example, a contractor takes advance payment for building a swimming but never starts the work. Case laws we have Edgington versus Fitzwater. A company issued a prospectus claiming investment funds would be used for expansion, but directors specifically intended to use them to pay off debts. Hence, false promise or future intentions made with no intent to fulfill it constitutes fraud.
Fraud isn't only limited to false statements or active concealment. Any act performed to deceive is also fraud. It can be forging signatures or manipulating financial records to mislead investors, etc. This can be seen in the case of Lloyd versus Gray, Smith and Company, in which a clerk in a law firm manipulated a widow into signing some documents which transferred all her property to him. The court held that this was a fraudulent act even though it was committed by an employee, and the employer was held liable. Additionally, some acts and omissions are automatically considered fraud under the law, like fraudulently transferring your property to someone else to avoid debts or to issuing fake invoices to claim tax benefits. This can be seen in the case of Rex versus Stilson in 1932, where the company issued prospectus to investors showing large profits, but they hid their financial losses. The court held them liable for fraud even though it was not direct misrepresentation.
Let's take a look at the remedies of fraud in contract law. When someone is tricked through fraud, the law provides some ways to fix the situation. So let's look through the important remedies and some of the case laws. Cancelling the contract. Person who was misled can cancel the contract and return to the original position. For example, returning of the product which was falsely advertised. Now let's look through a case with versus of Langdon 1936. In this case, the court held that the statement which was made, and after that, which the statement was false and which was not informed to the party about it, amounted to misrepresentation. The misled party can cancel the contract. Compensation. Basic compensation. Basic compensation covers all financial losses caused by the misled party. Punishment compensation. In serious cases, extra money is awarded to punish the wrongdoer. So now let's look to the case. Smith New Securities Limited versus Crimgear Vickers 1997. In this case, the party deceived in fraud is entitled to cover all the compensation caused by the fraud, forcing the other party to act. In rare cases, a court may hold the dishonest party to fulfill the contract as originally agreed. Now let's look through the case Beswick versus Beswick 1968. In this case, the court ordered specific performance because monetary damages were inadequate to provide justice. Criminal charges. If the fraud is serious, the wrongdoer may face fines or imprisonment. Now let's look through the case R versus Kelson 1932. A company director was convicted of false statement to mislead investors. Legal remedies protect victims from fraud and uphold transparency in contractual dealings.
Fraud undermines free consent, making contracts unfair and legally voidable.
Contracts have legal consequences, including recession, risk, and criminal liability.
Judicial interpretation of fraud ensures fairness and prevents deceptive practices in contracts.
Legal remedies protect victims from fraud and uphold transparency in contractual dealings.